Mr. President, the second legal principle by which the legality of Israel's occupation is to be assessed is Article 2.4 of the UN Charter, which prohibits the acquisition of territory through force, one of the most fundamental principles of the post-UN Charter era. The vast majority of states participating in these proceedings submit that Israeli occupation, by virtue of its permanence, de jure and de facto annexation, manifestly violates the principle of inadmissibility of acquiring territory through force. Only one state has attempted to justify Israel's actions by contesting the Palestinians' title to the occupied territories and justifying Israel's territorial expansion as the product of a defensive war. Egypt submits that these claims have no basis in fact or in law, and seek to derail the court by raising issues outside the temporal scope of this request. They are reminiscent of the archaic international law of the 19th century that justified territorial conquest through denying the sovereign status of colonized peoples, relegating them to the realm of terra nullius. There is also no support for the proposition that Israel was acting defensively in 1967. International law recognizes neither preemptive nor preventive self-defense, and the terms of the UN Charter on this matter are clear, requiring an armed attack to occur in order to trigger the right of self-defense. Israel's attack in 1967 was therefore not a defensive but an aggressive war. Even if the claim of self-defense were valid, which clearly is not the case, a decades-long occupation is not reconcilable with the customary international law conditions of necessity, immediacy, and proportionality. In any event, the issue is a moot one, as it is universally recognized that a state may not gain title to territory through any use of force, regardless of its purported legitimacy. These claims also find no basis in Security Council Resolution 242, which unequivocally recognized the inadmissibility of acquiring territory through force, demanding Israel's withdrawal from territories occupied in the recent conflict, and emphasizing the duty of all states to act in accordance with Article 2.4 of the Charter. Resolution 242 was reaffirmed by Resolution 338, while the inadmissibility of territorial acquisition through force was confirmed in at least 9 subsequent Security Council resolutions. In fact, Resolution 471 clearly stated, as far back as 1980, the overriding necessity to end the prolonged occupation of the Arab territories occupied by Israel since 1967, including Jerusalem.
אני רוצה במילה אחת לומר על ביטוי שהשתמשנו בו כאן ליד השולחן, שזו הייתה מלחמת אין ברירה. אני רוצה לקבוע שמלחמת ששת הימים לא הייתה מלחמת אין ברירה. היא פשוט הייתה מלחמה שטעמה את הקונספציה הביטחונית שלנו מאז הוקמה מדינת ישראל, שהיו בה כמה אלמנטים שאנחנו לא יכולים לתת לאויב להיות תוקף ראשון. ישראל לא יכולה. זה טעם את תפיסתנו שיש להעביר את המלחמה לשטח אויב. זה טעם את תפיסתנו שיוצאים למלחמה לא רק בגלל סכנה צבאית, אלא גם בגלל אובדן הרתעה, ואפילו מנימוקים אחרים.